Hello, and welcome to LGB Alliance USA's weekly news roundup. Today, we'll be covering the following stories. San Francisco's Harvey Milk LGBTQ Democratic Club has found voter fraud in its endorsements. A court affirms ruling that allows boys on girls' sports teams in Arizona schools. And at the end, we will have a special report from Ariane, who is going to talk about the Tremaine Carroll trial. So up first, San Francisco's Harvey Milk LGBTQ Democratic Club has found voter fraud in its endorsements. The Harvey Milk LGBTQ Club discovered dozens of fraudulent votes that influenced its endorsements in 7 November races. The club's president has since resigned. Acting President Melissa Hernandez told reporters, quote, "Several ballots had been cast by people that were counted in our records as being present at our meetings as eligible to vote. But when we did an audit, we realized several of them were either not eligible or not actually present." The fraudulent recommendations included 50 endorsements, some of which included 6 races for U.S. Senate, San Francisco City Attorney, the city's Board of Education, the City College of San Francisco Board of Trustees, and 2 city propositions. One of the more interesting compromised votes was on whether to rescind the club's backing of State Senator Scott Wiener for reasons that remain unclear as of now. The club held a revote where they issued voter verification codes and required people voting online to keep their cameras on. The club has hired an attorney to look into the fraudulent votes and hopes to release a report on their findings in the next 30 days. Court affirms ruling that allows boys on girls' sports teams in Arizona schools. The Ninth Circuit Court of Appeals has upheld a lower court's injunction preventing the enforcement of Arizona's law that stops boys from playing on girls' teams in schools. The case of Helen Doe versus Thomas Horn involved 2 boys ages 11 and 15 who were not allowed to play on girls' sports teams. The Save Women's Sports Act of 2022 banned boys from playing on girls' teams in Arizona. This suit was filed with the help from the National Center for Lesbian Rights, NCLR. A 3-judge panel on the Ninth Circuit Court of Appeals in Tucson ruled in an agreement with a lower court that until the case of Helen Doe versus Thomas Horn is settled, the Arizona law cannot be enforced. U.S. Circuit Court Judge Morgan Kristen wrote in the unanimous decision, quote, "The panel held that the district court did not clearly err by finding that before puberty, there are no significant differences in athletic performance between boys and girls, treating small differences as insignificant, and finding that transgender girls who receive puberty blocking medication do not have an athletic advantage over other girls." The court also found that the law discriminates against transgender students and that the plaintiffs were likely to succeed on the merits of their case. Rachel Berg, staff attorney at NLCR, said in a statement, quote, "We are pleased with the Ninth Circuit's ruling today, which held that the Arizona law likely violates the Equal Protection Clause and recognizes that a student's transgender status is not an accurate proxy for athletic ability and competitive advantage." We will keep an eye on this case and report to you if there is any change in the status. Up next, we have Ariane with a very special report about the Tremaine Carroll case in Madera County.
Hi, everyone. I'm going to offer some updates on the Tremaine Carroll trial. Just to give some overview of the case, Tremaine Carroll is a trans-identified male who is incarcerated in a women's prison in California and is facing 2 felony counts for forcible rape and 1 for witness intimidation allegedly committed while in the women's prison. He has since been transferred to a men's prison. A preliminary hearing was held on July 8th, in which a judge agreed that enough evidence was presented to bring this case to trial. Wolf, that is the Women's Liberation Front, had reported about this preliminary hearing previously. On Friday, September 6th, I attended online another hearing for the Tremaine Carroll trial. The hearing dealt with the fact that on July 29th, Carroll had submitted handwritten motions with the intention of reversing the preliminary court hearing and blocking the case from going to trial. These motions included a Marsden motion, as well as motions alleging a biased prosecutor and racial discrimination. A Marsden motion, by the way, is the means by which a criminal defendant can fire a court-appointed attorney and speak directly to the judge in the state of California. Now, the judge dismissed this Marsden motion because she said that Marsden motions are for appointed rather than retained counsel. Carroll was then asked if he wanted to keep his attorney, and he said yes, he's just angry he's not allowed to talk to his attorney privately. The judge said that the other motions were improperly filed, that Carroll should ask his attorney to file them rather than do it himself. Dates for submitting opposition and reply were scheduled for November 15th and 25th, respectively. The next court appearance was scheduled for December 2nd to discuss the 995 motion. A 995 motion refers to California Penal Code 995 and is a motion to dismiss charges following a preliminary hearing. There was some drama at the hearing about pronouns. At first, the judge referred to Tremaine Carroll as Mr. Carroll, but I noticed she at some point corrected herself to start using female pronouns. Also, when Carroll complained about being allegedly misgendered and insisted he identified as a woman, the judge mandated that everyone at the trial respect his identity and use his preferred pronouns, which are she, her. This made the prosecuting attorney quite upset. He claimed that given that Carroll is accused of raping women and that he is currently in a male prison, that he should be referred to by male pronouns. The defense attorney suggested that deliberation on pronoun use should wait until December 2nd, the December 2nd hearing, and the judge agreed. More drama erupted at the end when Carroll insisted on giving a speech to the courtroom against the wishes of his attorney. Carroll used the opportunity to blame racism and transphobia for the charges against him. He also complained that the prosecutor showed bias against him, which I am assuming is referring to the prosecuting attorney's insistence on using male pronouns. Now, it should be noted that this trial is taking place in Madera County, which is a majority Republican county in the very Democratic state of California. Republican counties have a history of being at odds with the California state government, including in matters regarding gender identity. For example, some school boards in more conservative counties in California passed laws mandating parental disclosure when a student changes his or her name or pronouns or starts using an opposite-sex facility. In response, the overwhelmingly Democratic California state government passed AB 1955, which bans public schools from doing exactly that. And now we see more conservative school districts filing lawsuits to block AB 1955. Of course, it was the California state legislature that passed SB132, which made it easier to transfer trans-identifying male inmates into female prisons, which of course resulted in cases like this to begin with. It's going to be interesting to see if Carroll's legal defense is able to successfully wield California law against what I imagine is a conservative prosecutor. We'll keep you updated as this case proceeds. Stay tuned.